Hello, everyone, and welcome to this Your Overseas Home webinar. Buying property in France, your legal questions answered. My name is Christopher Nye, and I am the senior editor here at Your Overseas Home. It's great to have you all with us, whether you're watching live or catching up on demand. This afternoon, we are joined by an expert in French property law, Leah Maynard from Buckles Solicitors will be discussing the buying process in France, and Leah will be on hand to answer all your legal questions, or rather, all your legal questions as relate to buying property, because Leah is not a visa lawyer, she's a buying property lawyer. Thank you for joining me today, Leah. Would you like to introduce yourself and Buckles Solicitors?
Yes, of course. Hi, Chris. Hi, everyone. So my name is Leah, and as you will gather from the accent, I am French. I am one of the lawyers with the French team at Buckles Solicitors, where we specialize in advising our British clients in relation to French properties, so that is buying, selling, and also inheriting. We are a small team of 3 lawyers, and when advising our clients who are purchasing properties in France, we are here to hold your hand through the process, review all the legal documents, make sure that you are happy with them, you understand them, and they meet your expectation, and then make sure that all the formalities are completed so that at the end of the day, you complete on your property purchase without any issues or without any concerns.
Thank you. Now, this session is going to be 30 minutes long. It's a Q&A, so I'm going to ask Leah some basic questions, but we would like it to be as interactive as possible. So please do ask your questions. Put them into the questions tab on the right-hand side of your screen, and I will put them to Leah as we go along. Any that aren't answered, we will try to answer after the event. So do put the questions out. No one else can see your questions apart from us. So don't worry about that. Before we start, I would just say that this session is being recorded, so don't worry about jotting notes down. If you miss anything, you'll be sent a copy and you can rewatch it at a later date. So, Leah, let's just start off with a general outline of the property buying process in France.
Yes, of course. We have prepared for you a small timeline of what the process looks like and the timescales that are involved. Obviously, the first step when buying a property is that once you have found a property that you like, you make an offer and that offer is accepted. So that's usually a good start. Once your offer is accepted, very often your estate agent will prepare an offer document which will record the usual terms and conditions. So, for example, the percentage of deposit that you're paying, whether there is any financing or mortgage requirements, and any other specific conditions that you may have for your purchase. But as buyers, at this point, you are still not locked into your purchase and you can still change your mind. Once the offer is accepted, the next stage is the signature of the preliminary contract, and this can take the form either of a compromis de vente or a promesse de vente. They both work in similar manners with some small legal differences. This is the most important stage of the purchase process, and very often for British buyers, it can be a bit shocking because you are asked to sign this contract quite early in the process. So it's super important that you make sure that the contract records all of the proper terms and conditions and that you understand what it says, because once you have signed it, you will have your 10 days cooling off period, and at that point you will be committed and you will only be able to withdraw and recover your deposit in full if some very specific conditions are not met. So you need to make sure those conditions are properly drafted. If you are applying for the mortgage, you would usually submit your application quite shortly after signing your contract. And once your mortgage offer is issued, you have to wait 10 days to accept it. So you get 2 cooling off periods. one at the signature of the contract and one to accept your mortgage offer. But if you don't go ahead and accept your mortgage, you could potentially be at risk of losing your deposit. So don't get confused with the mortgage cooling off period. It works very differently from your purchase cooling off period. Once you have your mortgage, the notaire will usually have finished preparing the file for completion, and then you will agree completion date with your sellers. Once everything is signed, you will be given a certificate of purchase, which usually you will take to the bank to open your French bank account, and you will be able to set up your utilities as well. Afterwards, as a buyer, you will be moved into your house, taken possession, and then the notaire will deal with all the land registries formalities, publish everything, and then at some point you will receive a formal authentic copy of your purchase deed, but this can take several months to a year, depending on how busy the land registry is. So taking into account from the start of the process to the end of the process, you're looking at about 3 months, 4 months from start to finish.
Okay, fantastic. That's very, very clear. Now, okay, a big general question. What's the biggest mistake that international buyers make?
I think very often the importance of the preliminary contract can be understated because it comes so quick in the process, especially in England. When we buy a property in England, it can take absolute ages before we are actually committed, and this happens very shortly before completion. Whereas in France, the timing is completely different, with a buyer becoming committed very early in the process, but the seller becomes committed as well. So I think it's better, personally. Otherwise, another common mistake is not paying attention to the documents that are annexed to the contract. For example, your diagnostic service, or if you're buying an apartment, your copropriété financial documents, because they will give you a lot of very valuable information about the property, and you should review them and, if necessary, use them to negotiate again the purchase price, depending on whether they reveal any potential issues with the property.
Okay, now our first question from the audience was indeed about surveys. Are surveys provided by the seller, and if not, how do we find a surveyor?
It is mandatory in France for the sellers to provide a set of surveys to all potential buyers. So that will always be provided to you by the seller. You do not have to provide your own surveys. However, so differently from England, the surveys you provided in France are not structural surveys. So they are on topics such as, is there asbestos at the property? Is there lead at the property? The state of the electrics, the energy performance certificate has become extremely important as well. But if you are purchasing a property where you have a concern in terms of the structure and you want a structural survey done, that is not one of the surveys that the seller will provide to you. There are actually now several RICS surveyors, British surveyors, who practice in France and who will provide this type of documents, but you will have to be careful to make sure that you obtain one as early as possible, because you will not be able to make your purchase conditional on a satisfactory structural survey. So ideally, you need your survey before you sign your contract, or you need to make sure that you receive it while you are still within your 10 days cooling off period.
Okay, that's interesting. I know they tried to bring in surveys that the seller provides in the UK, but people decided that they didn't trust them. So, so perhaps it's good to. But can one trust the diagnostic surveys in France?
Yes, absolutely. To be a diagnostiker, so a diagnostic surveyor, you need to have several accreditations that are issued by the French government, and it's also mandatory to have professional liability insurance, which means that if there are any issues or mistakes in the survey, your surveyor will be liable for it, and the insurance will pay out to cover for any damages. So absolutely very trustworthy, extremely regulated, like a lot of things are in France.
Fantastic, excellent. Now, if I'm asked to sign a a document for a small reservation deposit. Is that a normal thing? I know it is in some countries. Does that happen in France? And are you safe to do that?
So I have never seen it. It's not customary, and I would say it is a little bit of a red flag and something to be very careful about. In France, you will be asked to pay a deposit, but this is only due after you have signed your contract, and your contract will set out the terms and conditions, which are all statutory under French law. So they are extremely protective of the buyer, and there are several scenarios to make sure that your deposit will be returned to you. If you pay a holding deposit, so something to make sure the property is taken off the market whilst the contract is being prepared, the concern is that whoever is holding your deposit will not be regulated by French law. So there could be a risk that you will not get your money, even in circumstances where you should be, because you wouldn't have those statutory protections. Especially now, a lot of estate agencies are not authorized to hold client money, except obviously for their fees, which means that if an estate agent is asking you to pay money to them as a holding deposit, that's also a risk that because they're not regulated, it will be very difficult to receive your money back. For example, if the estate agency went into liquidation, your deposit would not be protected or returned to you. So that's obviously a very, very rare case, but that's just to highlight, that those kind of things are not usual or very well regulated in France.
Okay. Now, can you talk me through the bon de visite and what that is? Am I safe to sign that?
A bond visit is literally just a document to say that you have viewed the property. It's absolutely fine to sign it. Usually, estate agents will ask you to sign this to show the sellers that, yes, there are people actually coming and seeing the property and being interested in it.
Okay, excellent. Now, when we have found a property and we put an offer in, do you help at that stage? Is that the stage when we would contact you?
Yes, so ideally you want to contact us before you sign anything to formal. The offer is always a bit of a little grey area because you would still benefit from your 10 days cooling off period after the contract. So as a buyer, it does not commit you as much as it does a seller. However, especially if you have a fair amount of conditions, your offer will set the tone of the entire transaction, and anything you don't put in the offer may be difficult to renegotiate afterwards. And just to give an example, recently, some of my clients who are purchasing a property have been told by the sellers that there is a termite issue at the property and that they had obtained a quote for a company to come and install termite traps. And what my clients wanted were for the sellers to pay for this and for a year worth of maintenance of the traps. But because they didn't insert this in the offer that they made, even though they wanted it at that time, the sellers refused to have this added in the contract, and we ended up not being able to add this condition at all because the sellers said that the buyer made the offer knowing about the termites and not negotiating this specific condition. So that's why the offer, while not entirely binding on the buyer, should still not be taken lightly. So that is at this point that you want to contact us, say, we found the property, we've offered so much, those are the conditions, here is the offer, is this okay to sign, is there anything you think we should add, and obviously be aware of the deadlines to make sure that the seller is committed for long enough and that you are not also stuck potentially having to buy this property.
Sure. Okay. And I suppose on a similar theme, what about if we find the lovely property, and if it's anything like me, you think it's perfect, I just want a swimming pool put in, or I just want to convert that, or I just want to change the colour of the shutters. Is that something that I can imagine an estate agent say, oh, you can do all that, that's fine. Would you be able to tell us if it's possible or not?
Yes. So one of the things we can do for you is to contact the mairie. In France, the mairie, the town hall, is extremely important. Not like in England. It's basically your first post of call for all of those questions. and you need to get along with them because otherwise it can make your life quite difficult. So we can contact the mairie and say, those are, the plans, those are what our client wants to do. Can you tell us what the planning regulations applicable to this plot of land are, and how easy it is? Because sometimes the planning regulations tell you can do something, but the mairie has another idea and will decline if it doesn't match their favorite color, etc. However, if you tell me that I would not buy this property if I could not have a swimming pool installed, then it becomes a lot more serious in that we would need to negotiate a condition precedent of planning permission and make sure that there is a condition in the contract that says that if you do not receive the planning permission that you want, then you will be able to withdraw from the purchase and recover your deposit.
Okay, excellent. Now, we've got a question on fees from Andrew. I know this is a complicated thing because they're listed under the notaires fees, but they're all the fees, aren't they? So Andrew's asked, we've been told notaire fees are between 7 and 10% of the property value. Is that correct? And does it cover all fees?
So yes, absolutely. Your notaires fees, you are looking at around 8% of your purchase price. The price that you will have accepted. So on the estate agency's website, there will be the asking price displayed, and very often with a letter FAI, which means including estate agency's fees. So when you are paying the sale price for the property and the estate agency's fees, and then you've got to factor in an extra 8-9% for the notaires fees, though I always feel it's very unfair to call them notaires fees. Notaires don't get 8% of the sale price in their pocket. Most of this actually goes to the French state by the way of stamp duty, etc. So the notaires fees, which should really be called stamp duties, cover the notaire costs for drafting the contract, but also your publication tax, your stamp duty, etc. If you are applying for a mortgage, you should also budget for an extra cost of around 1% of the sum you are borrowing to prepare the mortgage deed, which is separate. And if you do want the services of bilingual solicitors like bancos, those fees would come in addition. So that's something that our fees are not state regulated like the notaires fees in France. So that's something we would negotiate between ourselves, but they do come in addition. So if you wanted to budget this, it would be on top of the 8% notaires fees.
Okay, excellent. Now, we've had two people asking the same question. Stephen and Laura have both said, if you don't need a mortgage, does it still take 3 months or so?
Yes, absolutely. The main thing that makes the French process be so long is that there is something called a preemption right. So where the preemption right works is that in France, once a preliminary contract is signed, the relevant local authority needs to be notified. And the reason for that is that they may themselves be interested in purchasing the property for specific reasons. So in rural France, the agricultural board, the SAFER, will have a preemption right. So they might say, actually, you can buy the house, but we want this plot of land because we need it for some agricultural policy we are developing. Or in a city, the mairie could say, actually, we've got our social housing policy. We've been buying apartments in this building for our social housing, and we actually want to purchase this. Most of the time, 99% of the cases, the preemption right is never exercised, but the local authority still has a period of 2 months to make that decision, which means that once they are notified, you have to wait this 2 months period until you can proceed with your completion. So just this gives you an additional 2 months, and then obviously there is the drafting of the contract, etc. I have never seen a sale with a preemption right complete any sooner than 2 months. You can do it quicker if there is no preemption right, but that is quite out of the ordinary.
Okay, well, plenty of time to go around the the markets and choose your furniture then. So
Absolutely.
Irma has asked an excellent question. Does the cooling off period also apply to the seller? Can they
No.
pull out during the 10 days or at any other point after completion?
No, that is really, I think, my favorite thing about the entire French purchase process is that once your seller has signed the contract, they can't withdraw. That's it. They absolutely have to sell to you. So while it might sound very scary to have to wait 2 to 3 months, it's not 2 to 3 months where you don't actually know what's going to happen, as the seller is going to withdraw, etc. No, absolutely not. The seller is committed from the time they sign the contract until completion, and they cannot, suddenly decide they want to sell to somebody else because they're offering more money. That's just not something that happens at all in France.
Okay, so no gazumping. That's it. That's
No.
good news. James has asked. Now, this isn't perhaps part of your brief, but I've read the question now, so I'm going to ask it. We are selling our UK home to fund a purchase in France. What is the likelihood of getting a small mortgage to pay the deposit on a French property while waiting to sell our UK home?
That sounds extremely risky and something that I would probably advise not to do. The issue that you will have is that by the time you sign your contract and you get your 10 days cooling off period, you are going to be committed. And no one in France is ever going to let you put a condition that you sell your UK property before you can complete your purchase in France. So any conditional purchase in France based on the sale of a UK property will absolutely never work. And that's because the French don't trust that property transactions are actually secure in England. They know they can take a very long time. They know they can fall through at the very last minute, which means that they feel it is unfair on the sellers to legally bind them based on an event that may or may not happen or may take 8 months to happen. So those type of arrangements where you need to sell your UK property before you buy in France is very risky. What you could potentially look at doing is like a bridging loan, but obviously the interest rate for those are always really quite high, which means that if you don't sell your UK property quite quickly, you could end up having to pay a lot of interest on your bridging loan. So those are also quite risky.
Okay. A question from Nicola, who I think may be one of our American viewers. She says, is the survey the same as a home inspection?
I don't know what a home inspection is.
Fair enough. Okay, you already speak 2 languages. You can't expect to speak American as well.
I know,
okay.
I'm really sorry.
Are you able to help American buyers, by the way?
Yes, we don't have an issue with this at all.
Okay, great. Okay. Ben is a practicing chartered structural surveyor engineer. Can he do his own survey, or does it need to be a French engineer?
If you want a structural survey, you can do it yourself. A structural survey is not something that exists in France. So obviously, if you get it wrong, you can only blame yourself. So that probably defeats the purpose. That's why a professional surveyor is always best, because if they make a mistake, they will have that professional liability insurance you can claim against for your damages.
That's a good point. Okay. Does the solicitor, this is from Bava, does the solicitor undertake checks on the property to identify issues like property boundary, undisclosed successor to titles, etc., before the promise de vente?
So the answer to that is going to be a very lawyery answer. Yes and no. In the promesse de vente, what will have been checked is that there is good title to the property going back at least 30 years. So that is something that is checked at the time of signing your promesse de vente. Boundaries are never checked and they are not legally guaranteed. So if you buy a property in France and you have a concern about the boundaries, The notaire does not give you a guarantee, and your seller does not give you a guarantee either. The only way to be 100% certain and have your boundaries guaranteed is to instruct someone called a géomètre, a land surveyor, to come to the property and to formally mark the boundaries. The issue with this is that it is a process that must involve all of your neighbors. So everybody outside, obviously you share the boundary with, have to be involved with the process. It takes absolute ages, like a lot of things in France, and it is expensive. So obviously the sellers will expect you to pick up the cost of that. And then what will be very difficult is to word the conditions that would let you withdraw if the boundary is not as expected. So you would probably need to think about, if the surface area of the land is like 20% smaller than I expected, then I would be able to withdraw. So all of that would be extremely difficult to negotiate. And was there anything else they were concerned about? Was boundaries? Something else that is checked, but that's only between signature of the contract and completion, is that the notaire will obtain a certificate d'urbanisme, a town planning certificate, and that will give you what planning rules are applicable to the property, whether there are any public easements that would apply to the property. The issue with this certificate is that unless it reveals something absolutely major, such as I am building an airport in your back garden, you will not be able to rely on it to withdraw from your purchase. So that will be a lot of useful information. But if you wanted to withdraw based on the results on it, it would have to reveal something absolutely major that would make the property impossible to use as a dwelling.
Okay. A question from Nick. When buying a residential property, are there restrictions on use, such as chambre d'hôte?
That's something that depends on which area of France you are purchasing in. There will be different levels. So some mairie will require you to declare that you are going to be using your property as a chambre d'hôte or as a gîte or as an Airbnb. Some mairie will say that it needs to be authorized by them, so you need to make an application. And some mairie will tell you, no, we don't care, just whatever you want. Especially in touristy area, usually you always have at least a declaration because they will want to charge you a tourist tax. So obviously, so that they know to charge you a tourist tax, it needs to know that you are using your property for touristic purposes. So again, if that is a project that you have, your first port of call would always be to go chat with the people at the mairie to get a better understanding of, what they think about those things. Keeping in mind, obviously, that all of those rules are never set in stone. So you could be allowed to use your property as a gîte, and then the region could feel that actually we're not attracting the right kind of tourist, and they start withdrawing authorizations, etc. So that's always a possibility. So that's why it's always good to chat with the people at the mairie to get an actual feel of what they think about that.
Sure. Okay. Now there's an excellent question here from Karen. I haven't sold my principal residence in the UK before I moved to France. She has heard that once sold, she will have to pay capital gains tax in France, as the UK house was now a secondary home. Is that correct?
Yes, that's correct. I believe so that's a question for an accountant. I'm not an accountant, so please speak to an accountant. I believe there is a tolerance. I think it might be a year. So you get once you move your tax domicile from one country to the other, they will usually give you a tolerance. I know it works the other way around. So if you were living in your main residence in France and then move back to the UK, so France would give you a year before you had to pay, you lose your main residence exemption. I believe there is a reciprocal agreement, but I'm not 100% sure, so please check with an accountant. But yes, that is a possibility, and I think the quicker you sell your UK property, probably the better.
Okay, that's an excellent answer. Thank you very much. We do in fact have webinars with a tax expert, Chase Buchanan. So do look those up on the website and come along and ask a question there. So Stella wants some clarification on this 10 days. If we sign the contract and deposit in place, if we change our mind before or on the 9th day, to be safe, we would get our deposit back, correct?
Yes, French law says that if you withdraw during your 10 days cooling off period, your deposit must be returned to you within 21 days of you giving your notice of withdrawal.
Okay. Now, this is not a visa question. It just looks like it is when you start off. We are not French. We're not French residents or national. Are we able to purchase the property in France, and are there any conditions?
Yes, France has no restrictions on nationality or residency to purchase. Obviously, depending on how much time you want to spend there, you will want to look at the rules that tells you how much time you can spend. Obviously, since Brexit, British people can't spend as much time in France as they used to, but you would need to speak to a visa or immigration specialist depending on your specific circumstances and also your objectives. But in terms of buying, you can absolutely buy a property. It may be that you can't spend 6 months in it every year.
Okay, fantastic. We're going a little bit over time. I hope that's okay with you.
Yes, of course.
It's okay. It's okay with me. Okay, Nicola has asked about inheritance. She has said, how can we deal with the forced heirship when one spouse passes? Nothing can go to the children at that point, only after both of us have passed. Is that correct?
So forced heirship is obviously a very big topic, and for people who haven't been Googling French inheritance law in the past few weeks, just to explain, forced heirship is a principle that says that your children have to inherit from you, and you can't disinherit your children. It's always a problem for the British because culturally we like our spouse to inherit and then the children have to wait, which, makes sense for me, but doesn't make sense to French people. There are some ways you can go around forced heirship. There is one way that is called a tontine provision. It's something that you insert in your deeds at the time of purchase, and it basically works like a right of survivorship, in that when the first one of you dies, the survivor automatically inherits their share, and it doesn't pass in their estate, so there is nothing for the children to inherit. Other things you can do are to do with matrimonial regimes, and there is also the European succession regulation that is quite helpful in having English law applied to your property rather than French law. But the French don't like that very much, and I've been trying to restrict it. It's quite a vast topic. It is something that we do advise on, either separately or as part of our purchase services. What I would say is that even if you don't want a lawyer to advise you on your purchase, do still take that estate planning ownership structure advice before you complete on your purchase, because things like the tontine, which at the moment is the only 100% secure way of making the property out of reach of the children on first death, is only available if you have it on completion at the time of purchase. It's not like in England where you can switch your ownership after the purchase. So if it is a concern, do take advice, if only just on the estate planning side of things.
Okay. Question from Alessandra. For a house close to a river, do you get an environmental report on flooding risks?
Yes. So as part of the standard survey report, you get something called a risks statement, and this highlights natural events risks, so flooding, fires, etc., and also mining risk and pollution risk, so if there has been any pollution in the area. I think also one of the things you will want to look into if you buy next to a river is that the river is authorized and legal, and that there are no issues ongoing with the environment services. We've had a purchase where there was a lovely, lovely river on a mill, and the clients really liked it. But when we looked into it, apparently the way the river was set out was bad for the fishes, and the river had to be moved further away to make the fishes happier. And that was going to cost 50,000 euros. So we managed to negotiate to split the cost with the sellers. So I think one of the things with France is that everything is going to be really heavily regulated. So like a pond, even a well, a river, etc. For us lawyer, all of those are red flags that make us go, oh, we need to look into it because it is potentially something costly that's going to happen with this very lovely feature in that property.
Okay, fantastic. We've got an awful lot of questions on surveys, but I think we'll perhaps do a separate webinar on those at some point because we are running out of time. Here's one from Mark. How important are the energy performance figures to the value? We're looking at one with an E rating. Does that matter?
That is a super question, Mark, and I'm actually really glad you asked it. The energy performance certificate, 3 years ago, I would have told you, don't worry about it, it's just a tick box exercise. Since last year, the French government has started really cracking down on what they called energy calendars. So it's basically a property where the heat is basically leaking out of the property because it is so poorly insulated. And as a result of this, France has introduced a number of regulations that are going over time to force people to carry out those energy saving building work on a property. If you are purchasing a property rated E, you must be provided now with something called an energy audit. And the audit is going to give you an idea of the costs to bring the property into the acceptable energy ratings. And where it is becoming a concern is, of course, when you come to sell the property in the future. If you have left it at an E rating, there is a risk that the French government will have introduced new regulations to either prevent you from selling it until you have actually carried out the building work yourself, or will make it a lot easier for the buyers to negotiate the price down. So do have a very thorough look at your energy audit that you will be provided and make sure that you are happy with the cost of it, because there is, in my opinion, a very high chance that at some point the French government will use this data, because all the energy audits have to be reported and registered now. There is a high chance that the French government is going to use this data to start forcing people to carry out this building work because they do care about the environmental policies.
Okay, thank you. Now, I think we're going to have to let you go, but can we just go over the fees again, because there's lots of questions where people are confused. So the notary fees are about 8 to 10%, about 8%.
8%,
and then
yeah,
there
10 is
will
a lot.
be, okay, 8%, and then there's your fees. Is that a percentage or is that a fixed fee?
No, so the way we do our fees is we used to do percentages. We stopped doing percentages because we felt it wasn't fair, because some properties at a higher value could be very easy, straightforward transactions, whereas some properties at a lower value could actually be extremely complicated. For example, if you buy a barn worth 20,000 euros, but you want a whole host of planning permission to come with it, that is a lot harder to negotiate. So the way we do things now is that we always take the time to have a detailed conversation with our potential clients before the instructors, just to explain how we work and also gain as good an understanding as possible of the properties they're purchasing. Has the seller done any building work? Because then we would need to start checking that the relevant permission is in place, all of those things. And then based on that, we will propose our fees. We can give hourly rate options, fixed fee options, contract review options. So we are really flexible in that way.
Okay, fantastic. Well, I think we're going to have to call it a day. Thank you so much for all these fantastic questions coming in. We'll try and get those who haven't had those questions answered. We'll try and get them answered later. Thank you, Leah, for all your really insightful tips and advice. And to our viewers, we strongly recommend that you do get in touch with Leah and Buckles solicitors directly to discuss your requirements in details. Have we put a picture of that up? Yes, there's your details there. That's excellent. So you get a screenshot of those, or try and remember that phone number. And I would just like to invite any viewers, if they found this this webinar helpful, to leave us a review on Trustpilot. Then, yep, there's a link for you to do that. That would be great. Thank you again, and happy property hunting. And thank you again to Leah and Buckles solicitors. Thank you very much. Bye bye.
Thank you. Bye.